Hi, everybody. This is Paul Hitchcock. I'm with Barth Calderon. We're an asset protection, estate planning, and business planning firm located in Orange County, California, helping a lot of property owners across the country with their needs. And this is our channel where we bring you hot, updated, current items in the property owner space. And I have Alexandra Alvarado here, who's Director of Marketing and Education for the American Apartment Owners Association. Welcome.
Hi, thank you for having me back.
Yeah, and we're just going to do a quick and dirty one here because you got a very hot update. What's going on?
Well, there is a landmark case that we covered in our last issue of Rent Magazine that I want to share with more landlords. The name of the case is Henderson versus Five Properties LLC. A couple months ago, there was actually a landlord victory in a court, which is rare, right?
Woo! Yeah.
And it was actually a federal court. So this has national implications for specifically emotional support animal fees, which a lot of landlords for a long time have thought they can't charge because if they're an emotional support animal or a service animal, it's off the table. And the judge in this case has said otherwise.
Oh, wow. Meaning, emotional support animals. I just got to ask, it's a crazy question. Are those typically cats or dogs or both?
It can be almost any kind of animal. There's no specific type of animal that can qualify as an emotional support. However, service animal does have to be a cat, a dog, or a horse.
The horse thing. Interesting. I'm not laughing at that situation, but just
Yeah.
interesting. But okay, so what was the case then? So what are the details
Mhm.
of the case?
Yeah, so there was a woman who applied for this rental, and apparently the rental did allow pets, but they did also charge her for an emotional support animal because she claimed that the animal was emotional support and not a regular pet.
Okay.
So once she said emotional support, which is what a lot of tenants try to do to get out of paying the fee, the landlord said, no, we're still going to charge you the fee. Then the tenant took the landlord to court and said, that's illegal. You can't charge me for my emotional support animal. And the judge in this case actually reviewed the law, which is the Fair Housing Act. The Fair Housing Act doesn't actually specify that you can't charge a fee.
Interesting.
However, HUD's joint notice with the DOJ on emotional support animals, which was issued back in 2020, did say that you can't charge a fee. Now, that is a notice, it's guidelines, it's not actually law, but it was
Oh.
treated like law. And
Oh.
there's precedence showing that if an agency, a government agency issues guidance, that it can hold some influence, but ultimately it's not breaking the law. It's not actually the law. The Fair Housing Act is the law, and HUD's guidance is the interpretation of that law. And
Oh, okay.
so that was part of it. And the other part was, well, is this even fair to the tenant, right? The whole point of the Fair Housing Act is fairness, right?
Right. Yeah.
So if someone is being treated differently or they're unable to enjoy their home because they are disabled in the same way anyone else can, right? Then that's really what the purpose is. And in this case, pets are allowed in the entire building. So that's not an issue. Her having a pet was never a problem. Everyone was being charged the fee. It wasn't just her because she
Okay.
asked for the emotional support animal. And it wasn't an unreasonable amount, meaning that she wasn't being charged so much that it was actually causing her to not be able to rent the place. She could afford it. The fee itself was 3% of the total rent amount.
Yeah, not double the rent or anything like
Of
that. Yeah.
course,
Yeah. Yeah.
yeah, and everybody was paying it.
Yeah.
So it really comes down to, are they being treated differently because they have a disability? No, they're
Hmm.
not. They're not being
Mhm.
treated differently because they have a disability. However, let's say the individual could not afford it and the fee was really high, and or it was a fee that was only being charged because it was an emotional support animal. That's then where the fairness aspect would come into play, and then
Right.
you could make that argument. So the judge basically said it all has to do with a case by case analysis of each request. Number one, how much are you charging? What's the proportion of that fee to the overall housing cost? So in this case, it was 3%. The judge did not say what is a reasonable fee, but 3% in this case to them was reasonable. So I would say
Yeah.
if you're at 3% for a fee, you're kind of safe based on this case. And also, how many other tenants or the proportion of other tenants that are paying that same fee as well. The importance of that fee waiver to the handicapped tenant, can they afford it, right? So all
Hmm.
of that was part of the analysis. So this, I think, is a relief for many landlords to feel like, they don't have to necessarily waive the fee just
Yeah.
because someone says, I have an emotional support animal and I don't want to pay it.
Yep. Great update. Awesome as always. I know we're just doing a quick hit here, but very good. I'm telling everybody, if you're watching this, wherever you're watching, as we simulcast this everywhere on YouTube, LinkedIn, Facebook, is Alexandra's information will be connected around the video. Get in there. Organization is great. A lot of content that goes out. If you own rental income property, got to get connected. Thank you, Alexandra.
Yeah, thank you. Visit AAOA.com to join the association, and you can see the magazine in the menu if you want to read that specific story. But we have tons of free resources on there, like you said. So check it out, AAOA.com, and we'd love for you to be a free member of our organization so you can get all the free resources we have to offer.
Love it. Awesome. All right. We'll see you soon.
Bye. Thank you.